I want to first say I'd like to volunteer for anybody who likes to monitor the marijuana dealers in town. I've heard a lot about it. I don't know much about it, but I'd like to learn. So if you need a volunteer, I want you to let me know. My talk today is going to be about the Equal Credit Opportunity Act and guarantors. To be or not to be, that is the question. Whether 'tis nobler in the mind to suffer the slings and arrows of outrageous fortune, or to take arms against a sea of troubles, and by opposing in them, to die, to sleep. No more, and by a sleep to say we end the heartache and the thousand natural shocks. Now that's going to give you English CLE credit today. We'll put that down. As some of you may know, or if you have Wikipedia like I do, I found out, this is the third act of Hamlet, and Prince Hamlet at this time, he's in a bummer mood. He's in a bummer mood because his father's been killed, his uncle did it, and he's now looking at life going, kind of, woe is me. Kind of like when you go to a borrower, and for years and years and years you work with that borrower, and you lend money to that borrower, and you work with that borrower, and at the end they tell you, not only am I not going to pay you, I'm going to sue you for violating the Equal Credit Opportunity Act. And at that point you go, I think I feel some slings and arrows. I think I feel, woe is me. And if you'll recall last year when I gave a talk, I said, it's time we kind of stood up. It's time that when the defense lawyers in these cases are going out and filing 100 to 200 pages of documents against the bank, that we stand up and affirmatively fight that. And I'm happy to report we have a case now that we have a little light at the end of the tunnel. And I'll explain what light we have and why we have it. But that case started with our good friends at Community Bank of Raymore. And they had a client that they worked with over the years, lent money to, worked hard with, and their reward was when the client did pay. Not only they didn't pay, but the spouses of two individuals ran to the federal court and filed an ECO action against the bank. Now this case, there was a development company, LLC. Mr. Gary Hawkins was a member of that development company, and a trust of the Pattersons was a member of that LLC. And the bank, in addition to having the company sign the loan as the applicant, had Gary Hawkins, his wife Valerie, Janice Patterson, and Chris Patterson all sign guarantees. As a matter of fact, in this case, they volunteered it. That's another issue we'll talk about later. The importance about this is that under the Equal Opportunity Act, it clearly states the ECOA makes it unlawful for any creditor to discriminate against an applicant with respect to any aspect of a credit transaction on the basis of marital status. And then it defines applicant as any person who applies to a creditor directly for an extension, renewal, or continuation of a credit, or applies to a creditor indirectly by use of an existing credit plan for an amount exceeding a previously established credit limit. So what happened is Mrs. Hawkins, Valerie Hawkins, and Janice Patterson went to federal court and said, not only do we not want to pay, but we want attorney's fees, we want damages, our credit's been hurt because you demanded that we owe you money, and they filed a suit against the bank. There's another state court case, I won't go into that. I'm happy to say that Community Bank of Raymore did take action. And in that case, in the Western District of Missouri, we did attack that plan, filed a motion for summary judgment, and the court in the Western District of Missouri followed the Eastern District of Missouri and ruled that guarantors in Reg B, as it applies to guarantors, have no standing to sue, and that the ECOA only applies to the applicant, and an applicant is not a guarantor. Now you've got to understand why, because again, there's going to be a flux of what happens here. That is not only good news, but that case then got appealed and went to the 8th Circuit. As some of you know or may not know, there are 13 federal circuits in the United States. Missouri is in the 8th Circuit. We have South Dakota, North Dakota, Missouri, Arkansas, Nebraska, Minnesota, and I'm missing somebody. Each circuit, up until this point, no one circuit has ruled that guarantors were not protected by the ECOA. So this was a pretty daunting task that we had. I first want to say my partner is here, Greer Lang. Greer is over here in the corner. Greer did the laboring order. So we were in the car driving to St. Louis, where the Court of Appeals, Federal Court of Appeals is. And I'm peppering her with questions because we're going to sit together up in front of the bench. And at the end, she just said, "Okay, just do 2 things. One, don't get any of the judges mad by doing something. And 2, just try to look pretty." Now, the looking pretty part might surprise you, but yesterday I played golf with Bryce and his wonderful wife Marilyn and Kenny, and we would go up to hole sponsors, and I would get misidentified all the time. They were either calling me Bruce Willis or Brad Pitt. I didn't understand. So it was a good guy. And I think that Bruce Willis and Brad Pitt had to do to how much they were drinking before I got there to the hole. So I went up to the 8th Circuit. I didn't get any judge mad at me that I know of. How pretty I look. We won't bring that to a table vote today. But questions were fairly fair. You have to understand, the First Circuit, Second Circuit, Fourth Circuit, and other than the Eastern and Western District Courts, not appeals courts, all had kind of gone along with the fact that the ECOA applied to guarantors. So this was a long shot. The Missouri Supreme Court says that ECO applies to guarantors. I mean, that's a dilemma. I'll talk about that later. But it says that. Well, why do we have could we have two different rulings? The ECOA is what they call concurrent jurisdiction. You can bring it in the federal court, or you can bring it in the state court. Makes it very confusing for us lawyers to give you a good answer, and I'll explain that a little later. But it shows you what the odds were of doing this. Surprisingly, we actually had some judges who were very nice to us. It seemed like they might be on our side. So we weren't feeling terrible when we left. Went back. I knew I was giving this talk on this subject. So I was feeling a little terrible. Because what if we lost? Then I got to tell you about how badly beaten we were for the rest of this talk. Now I'm happy to say we did not, but I was a little worried. Obviously, you can't take judges for granted. And then our case was decided in August, and in July, the 6th Circuit Court of Appeals issues a decision on the same subject and rules against us. And of course, the lawyers from the other side sent it to the 8th Circuit Court of Appeals. So here we had been feeling fairly good about ourselves, and here the 6th Circuit Federal Court of Appeals rules that the ECOA covers guarantors, and of course, that whole case gets sent to the 8th Circuit so they can review their ruling. Now I'm a little more worried about this talk I'm giving today. I mean, what can be done? Well, what happened? In August, 8th Circuit Court of Appeals has done kind of what no other Court of Appeals has done, and it ruled that the language in the statute, what Congress said, is not ambiguous, it's clear, and the ECOA applies to applicants, not guarantors. It said, 6th Circuit, we understand what you said, but you said they were a third party to the agreement. As soon as you said third party, that means you're not the party. And Congress was clear about that this had to do with the applicant. It did not give rights to guarantors. Now, what also helped us is that when this law was passed in 1974 and 1976, there was an amendment. when the Federal Reserve Board came out and did its Reg B, which is really the problem that we have, the Federal Board agreed and said this does not apply to guarantors. Then in 1986, without any act of Congress, the Federal Reserve Board decided that they wanted guarantors to have the right to bring a cause of action, not just rely on the applicant. They changed the wording and said from now on, these particular sections apply to guarantors. And then, as you know, now we have a whole raft of rules under Regulation B that not only apply to husband and wife, by the way, but also apply to any guarantors. For example, there's a section now under Reg B that says that when you come up for a renewal and you do a credit analysis, in that credit analysis, you have to do a credit analysis on the guarantors as well. And if you feel that some guarantor isn't needed, that doesn't mean a spouse, it doesn't mean a brother, it doesn't mean a sister. If some guarantor is not needed, you should take the least approach of trying to secure their credit and let them off the guarantee. So they have now even broadened the scope. And so where are we? So the big question is, okay, where are we? What do we do today? Well, right now the answer is confusing, but I'm going to try to explain. Because of concurrent jurisdiction, the Eighth Circuit has now ruled that it does not apply to guarantors. And under another U.S. Supreme Court case, when there is a dispute between the agency and the Federal Court of Appeals, that Federal Court of Appeals wins. So theoretically, right now, in the states that I just told you, including Missouri, and the Eighth Circuit, if there is a dispute, which is now at the CFPB, but if there would be a dispute with them, or the state of Missouri, Division of Finance, over a Reg B issue on a spousal guarantee, the Court of Appeals wins. The problem is, I'm not sure the regulators will view it that way. The regulators have a lot of cases from around the country that say the opposite. They certainly have not come up with a new Regulation B just for the Eighth Circuit. And so what will happen is most likely they will come into your banks and pretend that the Eighth Circuit Court of Appeals decision doesn't apply. And they're going to examine you just like they examined you before. And so my first suggestion is, A, obviously if you get along great with the examiners and you're doing something they like and it's not harming your bank, keep doing it. There's no reason to look for a fight. So if you're working with your examiners, they're happy with what you're doing, you're getting good results and getting your loans collected, keep them happy. There's no reason to pick a fight where you don't need it. If, on the other hand, this becomes a big issue to your bank, the only way to really get the examiners to have to abide by the Eighth Circuit decision is to go to federal court and file a declaratory judgment action or file an injunction and make them comply with the Eighth Circuit. So I hope you don't have to go there. So I'm not telling you just because a regulator comes in now pick battle with them. You don't need to pick battles where they're not needed. But I am telling you that if there really gets to be a problem with the regulators, okay, here's your only avenue. The avenue is to go into court, federal court, and have the federal court, and I'm sure they will do this, they will order the federal agency as to the Eighth Circuit to follow a different set of rules. That will cost money, avoid it if you can. Second of all, what about, where are we with borrowers? Where are we when people come in the door, a husband and wife, and I know the typical rule. The typical rule we've all learned is that if, and I'll use this for an expression, if the husband has credit, but the wife is on some real estate, and you think the husband is creditworthy, what do? You have the husband sign the note, and you have the wife sign the deed of trust, right? But you don't normally have her sign the guarantee. You may, but for sure, under the regs, you only have her sign the real estate document that you need. Because the regulation B actually says, we don't want you to get more than you need. Now, when you think about this and why the ECOA came into existence, it's totally contrary. ECOA came into existence to include women in the process, to allow them to get credit. It wasn't meant to exclude them to get credit. All the exclusions about the guarantors and all about the exclusions about not getting people to sign came from Regulation B. It did not come from Congress. It did not come from the history of the ECOA. They want to include women on their own. They can apply for credit, they can be guarantors, they can be owners. They want no difference. Reg B has taken it another step. What happens now, you're in Missouri, you have a borrower, they're in default, or going into default, what should you be thinking about now in view of this case? The first thing is, how the heck do I get to federal court? And you don't get there automatically, because if you have a Missouri bank and Missouri resident, you don't have diversity of citizenship, and so you don't automatically get to federal court. So what do you have to do? And I mean tomorrow and the next day. What should you be doing now to get this decision to help you? Number one, you need to change your loan document forms. I know you hate to do that. They're so nice. They print off and you fill in the blanks and numbers go flitting in there, and you just hate to touch them. God, if I touch them, what have I done? Well, you have to touch them because you need to put in there that the law that controls your loan, let's really talk about guarantees, that's what it's about. In your guarantee agreement, it needs to say that the provisions of law that apply will be the provisions that are in the 8th District Court of Appeals, and that will control the federal question. You need to put that right in there, and I put it right in there, and that's part of your loan document, that the guarantor agrees that if there's any federal law question concerning the ECOA, it'll be determined in federal court in the Eastern or Western District of Missouri. Both of those districts will go ahead and apply. So that's number one. Number two, there's also a section about venue, not just choice of law. So you have the choice of law section in your document, and you have a venue and jurisdiction. If you have a guarantor in the guarantee form, and by the way, we even have language for you in our outlines. So I'm not putting it up on the board, but back in the outlines that we have language for you can take with you. So put in your venue section, that venue and jurisdiction, they agree, a guarantor agrees, will be in the Western or Eastern District of Missouri. And that will be a huge help in getting this to the place where it stands by you. Do not wait till the borrower sues you in state court, because it's not going to work by you filing some action in state court. I don't know what the Missouri courts are going to do now. Maybe they'll relook at this in view of the 8th Circuit Court, but maybe they won't relook at it. The Missouri courts could still say, nope, our Missouri Supreme Court said it applies to guarantors, we're going to have Reg B apply to guarantors. We don't know what's going to do. So you've got to find a way to get them into federal court on the issue of guarantee. Okay? And again, we have language back there for you. Another thing, look at your loan policies. One of the things that we have found, and here's another very unique thing about the 8th Circuit Court of Appeals. I told you that right now we have the spouse signing a deed of trust. Might not have them on the loan, but we have them on a deed of trust to put up as collateral. Well, in our argument, I thought this was kind of unique, is one of the judges picked up that Missouri was a tenancy by the entirety state. And that judge was all over that. And as you all know, tenancy by the entirety means if it's held by a husband and wife, it is presumed as joint tenants. If it's held by a husband and wife, it is presumed to be joint tenancy. Now, I have seen bank account agreements. Somebody opens an account. I have seen some banks that in their agreements, they go joint tenants with rights of survivorship, not tenants by the entirety. I think they do that because they're afraid of garnishments or something. But I got to tell you, if you just have joint tenants, not tenants by the entirety, you do not get entirety protection for your customers. You have to have either just joint tenants with rights of survivorship or joint tenants with rights by the entirety. Now, what the Eighth Circuit said, which was going way beyond what we thought they were going to do, they said it was commercially reasonable in Missouri that a bank would give the guarantor of both spouses when financial statements that are given to your bank in turn contain assets by both spouses. And since spouses can exchange assets anytime they want to, you know there's no gift tax. You can give your spouse $1 million and take it back, and as long as it's your spouse, there's no gift tax. Because spouses can transfer property whenever they want to, really without much, with no tax consequences. That in Missouri it would be commercially reasonable to have a husband and wife sign if their financial statements show joint property and you're relying on that financial statement. So when you get a financial statement, it is really important to have it identified and signed in front of you by the husband and wife. Don't take signatures home anymore. If you have a notary's right there with you when you get these signed. All of these lawyers are picking out the fact that somebody got an extra signature or the person wasn't there or didn't read the document. So what you want to make sure of, is you get a financial statement and it's got a list. Joint, individual, his, hers, make them identify it, make them sign it. And if in fact you are relying on any joint property, you need to write that down in your loan policy. So you shouldn't just have a ratio. If in fact, because as we all know, real estate values change, businesses change, the economies change. One year you don't need, one year the husband or the wife's assets are plenty strong. The next year real estate drops 400% and now it doesn't cover what you're doing. And so what you need to do is to ensure that your loan policies, and put these in writing. And when you do a credit analysis, put it in writing that they have submitted to you a financial statement showing joint assets, that they have asked you to count on that asset, and you are relying on that asset. That ought to even help you with the regulators who want Reg B to be the way it says today. Now, Reg B does not say that. It says defer. Don't do that. Eighth Circuit says in Missouri, because the tendency by the entirety, you can do that. So where this is going to go in the future, we don't know. We can tell you, number one, this is a really good decision for banks, for a change, instead of getting kicked around all the time. Number two, you've got to get to federal court to get that decided. Don't wait for a lawsuit. Don't wait to sue them for their money. If you're having any trouble with a borrower, get to federal court, have it in your documents so you can get to federal court, and you can wrap that up and not have that decided by a state court. Number three, your loan policies, and your loan documents, and your guarantee documents need to be very clear that these people are acknowledging all those things I just told you. Plus the fact, and we really didn't get from the court, but I think another really great argument out there is waiver. You can have them waive any kind of liability under the ECOA. There are some cases out there that allow waiver. Doesn't mean some judge won't say it's against public policy or et cetera, but it's time to really, really cover your bases. So I think this is good news. I think that we finally have some action going in our direction. I like the opinion. It's well reasoned. We not only had two judges that concurred in the opinion, we had another judge that wrote an entire separate opinion of why we were right. That has not been appealed to in-bank. What I mean by in-bank is we had a 3-judge panel at the 8th Circuit federal level, and they could have appealed to the whole court. They did not. We're now waiting to see whether or not it's going to be appealed to the United States Supreme Court. Whether in this case, which it might be, that's really kind of up to the plaintiffs in the federal case, because we won't appeal it. We won. We like it. But it might be some other case, because now, clearly within a month, the 6th Circuit and the 8th Circuit have disagreed. And now you have the 1st and 2nd Circuit out there that disagreed before. You have the Eastern and Western District of Missouri saying, we agree with the 8th Circuit, and you have all kinds of other districts disagreeing with it. But you have to start somewhere, and we finally got something for you, and it's something workable, but you have to follow up and make sure we get you to federal court. If I can't get you to federal court, I can't help you. Look at those loan documents, look at the language and the guarantees, make sure they're right and get you where you want to go. So that's good news. Now, I thought of maybe ending with another Shakespearean quote, parting is such sweet sorrow, but that was kind of a bummer too. All these ones that people are dying in these things. And so I'm going to show you my age and kind of end instead with a quote from the famous playwright named Roy Rogers back in my day. And Roy, at the end of it, since I met you all here, and I have so many friends here now after coming here all these years, I'm going to end instead of some parting this with such sweet sorrow and dying, I'm going to say, happy trails to you until we meet again. Thank you.
This is on. Just a couple of comments about some things that I've observed here this morning. First of all, Daryl and his basketball stories, he's going to be available in the exhibit hall later with his short basketball pants on in the Ice Bucket Challenge booth at the front of the thing. So, it was interesting to listen to some of this. Bob Monroe, I want to tell you, I was, the Wall Street Journal this morning reported that Home Depot had 2,200 stores across the country were violated with this breach. It was also reported that your wife was in 1,735 of them. So that. And a little note for Rich Weaver, for 30 years he's been unable to get a free drink from anybody when he was working for the Missouri Division of Finance. He's available now. I try to tell him, look, you're a vendor now, you pull out the credit card, buddy, that's the way that works. And Tom Stahl, it's hard to follow you talking about marijuana and then quotes and then, but dude, Brad Pitt, are you kidding me? What were you doing all day on the golf course? All right, well, I know that when some people saw that I was going to talk about the board of directors, there was kind of a groan. In fact, one of my clients told me last night, are you going to try to scare the crap out of people again like you've done through 2008 through 2012? And that was the era of the onslaught of bank closings, and I'm not going to do that today. That'll be a little lighter. This will be a little lighter, I hope. We're not going to talk about banks getting in trouble and what happens to the board, but we're going to talk about good banks and trying to get the most out of the board of directors. By the way, just a note, when banks were closing and we had all these problems in 2008 to 2012, all the lawyers that I know got up at these events and talked about the onslaught of what they perceived to be shareholder lawsuits of failed institutions against the board of directors. It never happened. Now, the FDIC didn't find a director of a failed bank that they wouldn't sue, but they tried to hold the feet to the fire of everybody, but shareholders, for the most part, were very understanding about it. I was shocked, and I think most lawyers were. So that those types of things just really didn't develop. But let's go back before 2008 and talk about boards and community banks. I think there are really only two types that I remember. See, there's some good boards and active boards, but there were two troublesome boards. One is the group that came in, ate lunch, voted yes on everything, and got a very limited information. The agenda for the meeting often was, they just changed the name at the top to minutes, and the bullet points remained the same, and it moved forward. The other type, there was always a problem with some meddling boards, where board members would think that they were now in charge of the bank, and so they'd go in and direct tellers to change the way they were doing things, or personal bankers, and that was more of a problem really than the sleepy board. So this presentation is just going to be about some observations I've had through the last 30 years or so about the effective boards. I hope it'll enable some of you to become more get a more effective board. First voice, I always do this. How many CEOs are in the room? Would you please raise your hand? Ah, plenty. How many board members? Board members, inside, outside, just board members. More hands go up. And how many regulators are here? Good, not a single regulator. This will be great. All right. So I will talk about liability just a little bit. When you're getting your board members, there's usually, you can tell them about 40 or 50 things that they're supposed to look for, but you can distill that into really about 5 items. And the first thing is just trying to tell them about the banking industry. It is a unique industry, and it has, so explaining that before they come on board and what the responsibilities are and things, that is a big part of it. I would not, in selecting a board member, you select them for many things, but letting them know about the banking industry is very important. And I think, like any board, you see this even on not-for-profit boards, you'll have people that are on there for maybe 3 reasons. One, you find some leaders. You really like to have that on your board of directors. You want to have some workers. Those are the ones who are out there in your community, telling the community about your bank and bringing business to the bank. Those are great. And then some you bring on just for reputation. They're the pillar of the community, and you don't really need a whole lot from them except to be there and, as Tom said, look pretty. Well, I don't know about looking pretty, but the reputation is needed to have good people from your community on the board. So those types of things are great. The second point I make with them is that it's just common sense. You're going through and making decisions. You're not an insurer of every decision. All you really need to do is use your common sense to make a decision you feel is right and based upon the information you have at hand. And you can rely on the management or the information you receive from management. You can rely on that. Now, as Ronald Reagan once said, you trust but verify. You do have to continue to do your oversight with regard to management, but just common sense on making decisions on a day-to-day basis is very good. Third thing is to be aware of and to give notice of all conflicts of interest, whether it's your brother-in-law's loan, your third cousin twice removed, if there is some connection to you of a loan that's coming before the group, or if there's any type of transaction, make sure you tell people about it and that it appears in the minutes. And if you need to abstain from the discussion and from the vote, do so. Fourth thing is all banking opportunities, all financial opportunities that come your way, you need, as a director, you need to bring that to your bank first. A lot of times somebody will get a loan and say, the neighborhood bank or the bank across the street really could handle this better. You don't get to make that decision yourself. You need to bring that to the board, let the board consider and decide whether they want to do it or not. If they don't, then you're free to go ahead and refer it somewhere else. And then the fifth thing, I think it's probably the most important thing, is confidentiality. Having the board know that everything that's said within the meeting is confidential and is not for public consumption. I think many of you have heard me tell this story before, but I had an example of a loan that was brought to a board of directors that I represent, and it's on a Thursday afternoon. I recall this very clearly, and they turned down the loan, and the loan was brought up, but there were 2 people on the board who were involved in related industries to the potential borrower, and they just said, really don't want to do business with this guy, just for that reason. So they turned it down. So the officer / director, chief lending officer / director of that bank had to go back and tell this person who he was trying to sell to use the services of the bank, no. And as he went back, he said, everybody was kind of in favor of it until your 2 buddies, Smith and Jones, told everybody that you just weren't reliable enough, and so they turned it down. So now Thursday evening, the guys, Smith and Jones, are having a beer at a bar, and the potential borrower, comes in with a couple of his buddies and starts a confrontation. They were smart enough to leave, guy said, I was gonna go out and get my gun out of the car, and I thought, nah, I better not do that. He went home. I kept going for because of that. But, so I got the call Friday morning, and they explained what happened. And by 11 o'clock, we were having the guy clean out his desk, and on Monday, we had the board meet and vote him off the board and take care of it. Confidentiality is so important, it has repercussions that you may not consider, but I think you need to emphasize that to folks. There is, I know that the lawyers here have heard this. You go and you talk and say, well, we really ought to talk about such and such and strategic planning. And I said, we don't want to do that in a board meeting because Tom will tell everybody in town. You can't have that on your board. And when you start thinking that that may happen, that's the time to ask Tom to step down. So I think some lessons to take away if I was a board member is that when I came on, I have really three things I got to remember, and then I'm going to be absent of liability. One is I have to be educated about what goes on in the industry. So whether you send them to conventions like this, or you send them, bring people in and talk to them, or send them to there's many board type educational sessions, that's great. In the days before Rich Weaver, when we were allowed to have de novo banks in the state, one of the general things we would do is take the new board of directors of the bank and have a Saturday session where we would go through and educate them about the industry of banking. The accountant would come, the lawyer would come, and then the CEO would speak, and that was a great idea. And so getting educated is extremely important. And I think emphasis on loan evaluation and making sure that the loans are underwritten properly would be a key if somebody was going on the board of directors. And to stay away from liability, it's all about process and documentation. So any process for a decision is pretty easy. You have to have sufficient information. You can rely on management, but it has to be enough information that you can look at it and make a decision. And you have to get the information early enough that you can actually analyze it to make that decision. Getting the board packet on the morning of the board meeting and the meeting's at 11 o'clock, that doesn't happen, especially when you're making some significant decisions. So getting the information early enough to consider and digest it is important. And to the directors, I'd say, and you actually have to read it. You need to read it and look at it. It isn't just the process, you have to actually look at it and make sure you understand. You have to have sufficient time within the meeting to discuss it. So if you bring it up and it's just a quick 5-minute zip through and somebody explains what the loan's gonna be and there's no questions and you vote for it, that's great, I guess, in most cases, but if that loan goes bad and it looks as if you've done absolutely nothing to analyze that loan before you voted for it, that's gonna be a problem. So then, and we'll talk about this in a minute, you have to have a culture within your board that allows people to feel free to ask questions and talk freely. You can't have Omar Gaddafi kind of running the meeting so that everyone's afraid to ask a question. And then there has to be a vote. And I've looked at minutes of banks that became troubled in 2008, 2009, and to have 5 or 6 years of just bullet point minutes saying unanimously approved, unanimously approved, unanimously approved, and then 30% of the loan portfolio went bad. Somebody really wasn't doing their job, and it looks, as to the regulator comes and looks at it, it looks like you're not doing your job at all. And so that's when liability raises a little higher. So I guess the big thing to think about too is in these meetings is during this process is you hope that you are setting an agenda that will allow people to think forward in planning, not just what's happened, and they get to take time to make sure they make their vote count. And on the documentation side, minutes are really an art form. I mean, some people take minutes and it's just very cryptic and it's one-liner for each discussion, and some try to take you might as well bring in a court reporter to take a full, it's in between there somewhere. And it is an art form, but you really have to do it properly. It is the only evidence, when things go sour, the only evidence of what job you've been doing. The regulators come in, what's the first thing they do? They got a team of people that come in, the graduate who is right out of college and has just been hired by the Division of Finance is assigned to look through the minutes. And they're taking a look and they're being really diligent. If they don't see the proper discussion occurred and things that happen, you're gonna have some problems. And I guess the last thing in your minutes, if you vote no, make sure that when you look at the minutes the next time, it shows you voted no. Or if you had a significant question that's very important, make sure that shows up in the minutes as well. Just one little thing about, for a legal point, I guess that would help. The exculpation clause that's available under the Missouri General Corporate Statute. The statute provides, so your bank holding companies in Missouri Corp, that you can eliminate the personal liability of a director to the corporation and its shareholders just with an exculpation clause in your articles of incorporation. Now, there are exceptions. You can't get out of the duty of loyalty to the corporation. You have to acts not done in good faith or excluded. Prohibited acts, if you did a wrongful dividend, for example, you didn't have the wherewithal to do that. And if a director derives a personal benefit. But other than those things, you have an exculpation clause. You are not personally liable to the corporation and its directors. Because the banking statute in Missouri does not address that issue, you can, because when you don't have it in the banking statute, you can go to the general corporate statute, you can put the exculpation clause in your bank articles of organization. And so that's something to be adopted and drafted, and I think that works. And for those of you in a national bank gets to elect the corporate governance statute that it's under. You have to have some nexus. It has to be located in the state, or it's got to be the state of incorporation. For example, if you were incorporated in Delaware, located in Missouri, you have a choice between Delaware and Missouri. Both of those, by the way, have these exculpation clauses. So the National Bank can get in on this act too. We just went through, you have to get it approved, and it's not the easiest thing in the world, but we have been able to do that. Larry Harris, my partner, is in charge of exculpation clauses, so they don't laugh at that. So when you're developing the board, as with any kind of planning thing, you need to start with an analysis, and usually the best analysis is done, I think, with the CEO and the principal shareholder. You don't need a whole crew of people. Just sit down and take a look at your board and look at the big picture. And so I started looking at diversity, and not in the sense of only one type, a diversity of backgrounds, so that you have not every wealth planner on your board. You have somebody with an accounting background, a salesperson, just a diverse backgrounds to bring to the board that will be helpful in developing the business of the bank. Age diversity, I think, is probably really important. Many times we're faced with succession planning. There's going to be a presentation later, but you look around the board and everybody is over 65. That's not a good way to develop business within your bank. You need to step that up and take a look at it. Gender is extremely important, I think, and I think if you're going to draw business from business women, you need to have some relationship to that board of directors, and I think that would go well. And I hate to say this because I know there's families in there that unless you're the dominant shareholder, don't think that there's a family seat that gets passed down from one generation to the next. Think of it in terms of business. It is that person that's going to take the place of John, who's retiring, going to be someone who can help the bank? And if it cannot necessarily be his daughter, it may be somebody else. But be open to that, and don't think that that's the way things are done. And then, before the person accepts the honor of being on your bank board, I think you need to sit down with them and have a really heart-to-heart talk. Not about the liability, but what you really want out of their performance. If you want them to bring their business accounts to the bank, tell them. We'd like to have your business as part of this program. Or, we want you to develop business for the bank. You're known in the community, we need to bring it in and track it and make sure that they're doing it. I think many times people let these board members go on and on for years and they're not adding any value to your business. Talk about the time commitment. I think most people tell, oh, it's going to be a couple hours a month at board meetings, no big deal. But tell them about preparation. They get the packet ahead of time, they're expected to read it, they have committee meetings they need to attend, and then attendance and reporting of attendance to the regulators is very important. And then, last but not least, allow them some educational opportunities. If the person is one of substance, they're going to want to know what they need to do. And then I would be very frank about the role of, if it's a very strong person, strong personality, I'd be frank about the role that you expect them to be. You don't want them to come in and run the business. They're there to oversee management, to make sure management is acting within policy. So, if I'm some of the biggest issues I think that have come up that I've seen, and I'll just run through these quickly because I don't want to run over my time, of course, is having that strong person come in and try to go in and tell people on the day-to-day management. There are people in this room that I know you face that issue, and I think you have to be very upfront with people about that. And if it doesn't work out, there's an exit door at each one of these meetings, and you can do that. Having a culture and developing a culture of mutual respect. Everybody's going to have an opinion around the table. If you have a strong board, there's going to be disagreements. Everyone has to respect everyone else's opinion, and you're not going to win every time. And you're going to have to let people know that. You're going to have to be okay with it. And as long as if you don't win, you have it noted in the minutes, move on. But that type of mutual respect culture has got to be in your board to make it effective. And probably if you have your local lawyer on the board, you're going to have to, who's going to express an opinion on every issue. You need to quiet them down and talk to them from time to time. You don't need a dominating discussion of one person on every issue. And sometimes that's the CEO. Nobody in this room would fit that. But if you have a board member that tries to do that, it's good to move them along. Try to stay on task with the meetings, but I do think you need to let the directors have an opportunity to add items to the agenda. And so ask them from time to time if they want to add a discussion regarding planning or a new branch, or if they have some reservations about something. Ask them ahead of time, maybe an email out to them the week before that, is there anybody who have an item to put on the agenda? And then, you don't want a room full of yes sir people. You want people that are going to be independent and think, but you have to also know when to part company. Being on a board of directors of a bank is not the Supreme Court of the United States. It is not a lifetime appointment. So a continuous analysis of what people bring to the table and whether they add something. And some of it may be, somebody may sit there and do nothing, but their reputation alone adds value to your business. That's okay. But you need to think about that from time to time. I'm not real big on mandatory retirement ages. I think that just causes more dissension than anything else. But I am a big proponent of doing an honest evaluation, having frank talks one-on-one with board members. So, key things, strategic planning. You need to involve your board. There are some banks that really just don't use their board for that. Make sure they stay alert for conflicts, not just abstain from voting. If it's sensitive enough, ask them to leave the room during the discussion. I think more and more we're seeing in acquisition documents, there was always a clause, 3 or 4 clauses, where the buyer would be able to attend as an observer the board meetings of the seller, so so you get a feel for what's going on. Then if the loan was above a certain amount, they would have to approve it, you know, within reason and some things of that nature. The regulators are coming down on that and are saying, no, you can't have those covenants and these agreements anymore, and you can't even be in the room because you would influence the discussion about operation of the bank. Likewise, I think when somebody has a conflict, the regulator's gonna extend that to say, leave the room and don't have influence the decision of what's going on. Make sure they know the policies of the bank. Lending. Make sure they know the lending policy of the bank, and if it goes outside the parameters, that the full board votes on those loans and make sure it's noted in the minutes. It's the one issue that comes up all the time in examinations. And then make sure you know you can rely on management, but you can also call in outside help when you need it, the accountants, the lawyers, consultants. And then keep them abreast of what's going on in the industry. For me, it was mobile phone banking. 4 years ago at Christmas, I gave my daughter and son-in-law a check. And now I'm a bank lawyer. My son-in-law whipped out his phone, click, and then hit another click, and it was deposited. And I was shocked. That was 4 years ago, and I said, well, what do you do with the check? He said, oh, well, I don't know, I just throw it away. Throw it away? I'm so old school, I'm almost like Papa Mom. It's good. So, in conclusion, the board seat at a community bank has always been a position of prestige and respect in the community. I mean, people want to be on the bank board because it means something. Make sure that the people you bring on are going to stay, are people who will maintain that kind of reputation for your bank. Thank you very much. And give over there.